Welcome. In this session, we will review the California Child Support Program as well as its practices and what is currently happening within the state. For this episode, we're going to look at California from three phases. The first is what exactly is happening currently in their processes. Two, how is the program implemented in California? And three, the remedies for which you could use to separate from the program. Hello, my name is Chris, and in this session reviewing California, we will look at how it comes into conflict with your constitutional rights. Let's get started. As you know, on this channel, we review case laws in the child support program, and we apply the rules, what we call the non-lawyer maxim. And each time we do a video, we talk about the ones that we rely on the most, such as in this case, it's litigants can assist by unlicensed laymen during judicial proceedings, and that's Brotherhood of Trainmen versus Virginia State Bar. We will say this for this year 2020 of that child support is a business. It always has been a business for the last 30 years, and we will continue to show this chart for 2018. Uh, as you know, they collected $28.5 billion from, what they call the child support collections, and they held on to about $1 billion for their services. In this specific video, we're going to look at what's called paternity establishment. Right there at the bottom, 1.4 million signed the acknowledgement of paternity. And we're going to use that later on as we examine California. Here is where we're asking, so please share this video, whether you're on child support or not. You should know if you are a citizen of the state of California, what's going on with the program, and follow us and press the like button. Let's take a look at the Census Bureau numbers for California and Texas. Texas has 28.7 million people, and California has 39.6. It is the most populous state within the union. Now, we did a few videos on Texas itself, and we show where Texas is unconstitutional as well as unbalanced. We suggest that if you've seen it before, go ahead and take a look at it again. You may find some tips and tricks within those videos. So let's start with the collections, what they call the collection numbers for California, which is prepared for Congress and its staff. And this falls on administrative wage garnishment of 45 CFR 32. And as you can see, from 2014 to 2018, it has been very consistent. It's about $2.2 billion. In 2018, it went up slightly. The child support program falls under, in California, what is called the Family Law Code. And let's review what is called Code 17202. This is where they establish the child support Title 4D program. And it says here, the department is hereby designated as the single organization unit and its duties to administer the Title 4D state plan program. But if you look further down in the code, it says that the state plan function shall be performed by other agencies as required by law, by delegation of the department, or by cooperative agreement. Now, we understand that most of Title 4D is a cooperative agreement, but delegation by the department, as far as I know and as far as our research knows, Congress did not give the state plan the authority to delegate to any other government agency. And we'll focus more on that, but understand it's inside their code and statute. Let's further look at what we call the director, the role and the job and the responsibilities of the director, and that is Family Code Section 17305. It says here, I've selected a few items. For instance, for those of you who are listening on a podcast, the office of the district attorney, that the director shall begin the transition to the child support agency pursuant to section 17304, because this is 17305, as of January 1st, 2001. So make a note of that. We're saying that the director shall transition from the office of attorney general to the child support agency. We just read that the actual legislation is Congress delegates the separate and single unit. It never said that the state or the governor created a department or director that transitioned from to the Title 4D program. It further in this statute says that the director shall consult with the district attorney. Well, of course, the director is going to consult with the district attorney because this particular director came out of the district attorney's office. It didn't come out of or born by what is called 45 CFR 301.1, which is a single and separate unit. So that right there is an unconstitutional process, right, being implemented by the state. This brings us to a section which we call to action. It's where we give you tips and tricks of how to separate from the program. As I've said, that we're going to look at California in three phases. And the last phase, which is the remedy phase, we will address in what we call our call to action section. So let's look at here the questions that were raised. One, I prefer this quote. Some people don't, but it's the art of war. It says, if you do not know your enemies, nor yourself, you'll be imperiled in every single battle. And that is, of course, Sun Tzu. Well, we know from the statute code of California, the department, which we are not sure what the department is, did not come out of the Department of Health. It said that the department transitioned out of the state attorney general's office. So that's a problem, right? So right there, jurisdiction should be the most, no matter whose paperwork you use, or you create the paperwork, or you decide to challenge them yourself and do your studies, you have to start there on a jurisdiction. Where did this department come from? If it's not within the congressional delegation of Title 4D. So let's get back to the Director's Code again. And this is section 17305. It goes on to further state in Part D that each district attorney shall, continue to be designated a single organizational unit. That doesn't make sense. Each district attorney shall become the single state organization. So the district attorney now reports into the Department of Health, and that individual district attorney or district attorney's office is the single and separate unit. Again, that is not what's delegated by the federal Title 4D. It goes on further by saying the director may withhold state or federal funding from the district attorney's office. So who is that person, the director, is holding money from itself? Basically, that's the way I read this section. So let's continue further. The single and separate unit, which is a Title 4D under 45 CFR 301, here is what we call the strategic plan for California. They had put this plan together back in 2015, and it's a 5-year plan that they wanted to achieve. I've also updated the name of the director of the program, which is Mr. David Kilgore. He was appointed director of California Department of Children's Services in June 2018. So right here, there should be some questions from you who are watching this video. The person comes out of the Attorney General's office, which is the director, which is now the director of Child Support Service, and Mr. David Kilroy. So right there are some problems. So as they put together their strategic plan, it was supported by these companies. And who's congratulating them on putting together a strategic 5-year plan? That is Deloitte, Conduit, CGI, and Equifax. And note Equifax. Isn't Equifax the what we call the credit agency. So, how can a credit agency be celebrating with the Office of Child Support in California or sponsoring them for anything that they're doing? So, right there is a conflict of interest, and a potential remedy for your court case. Now, we have not touched on any of these companies, Deloitte and Conduit. In future videos, we will talk more about their roles, responsibilities within the Title 4D program. So inside the strategic plan, we've decided what we call pull out or take apart things that we thought that were critical and that you could use to separate yourself from the child support program. Under the technology and improvement, what they call delivery of the program, we noted on item number 2, it says the ability to file liens and to collect child support electronically from the 5 largest financial institutions within 5 years. In my year-end video, I talked about that the Office of Child Support decided to sign a multi-year billion-dollar contract with your employers and with the financial institution in order to do what? As California says, in order to extract or put more liens on the fathers. Partnering with employers and meet the needs of families. This is another one of their objectives within the strategic plan. The item that I focused on was increase the percentage of collection that comes from income withholding from 67% to 80%. So think about that. They wrote a plan to take more money from you from 67% to 80%. That means for every dollar that you earned in California, their anticipation is to take 80% of that, leaving you with about 20% for your taxes. So if there weren't any taxes, their strategic plan probably would have said to take 90% because their goal is to take relatively all your money. Further down in the strategic plan, it talks about increasing the number of employees who participate in the income withholding program. Right now, they want to increase that to 25%. That means there are employees out there that are not part of the program, and one of their strategies is to encourage them to participate. At the bottom of the screen, I have here my 2020 strategies. I talk more about this entire process of how the child support agency is trying to ensure that they have pretty much what is called a direct access to your employer. So let's move on to the next, which is called the payment system. Again, this is another one of their objectives. What I'd like to highlight in this particular target is that they want to increase the percentage of the consent orders established from 24% to 40% within the 5 year period. Now, why consent orders? There are many other gentlemen on YouTube and various channels that talks about that the child support Title 4D program is a voluntary program and it's by consent. And that actually is true. It is by consent. Unfortunately, they leave off the most important piece, which is it's by consent while you're sitting in the room and there's 2 police officers with guns ensuring that you do not leave that room without signing the consent form. So the next strategy is judicial branch. And it says here to increase access to the court system in order to ensure child support orders. So this goes back to the theory that I've had with many people. Child support is not part of the judicial branch. They contract their services, but they are not part of the judicial branch. They are a program from Congress. They just happen to use the family court system and the district court system within your county. So in this particular California strategic plan, they want to implement that and use that even more. Next objective is the measurement of their performance. In other words, they want to do things very quickly. So we highlight that is to reduce what the number of what's called establishment cases. It takes them approximately 195 days in which to establish that. They would like to reduce that to 110 days. Again, the whole goal is to be able to exercise and implement this program throughout the state. And here's something else that comes from this strategic plan. They want to reduce the cost to $2.43 uh, uh, to three from 243 to $3. What they're saying is they want the most cost-effective way in order to institute this Title 4D program. That's a target goal. In California, they projected in 2018 that the arrears on child support will be about $17.5 billion. In Texas, it's about 16.9. So they're pretty much on par. They have the same amount. And how are arrears calculated? We've said this in our videos. They basically made it up. This particular case law, which is called Kessler versus Kessler, it says here the courts need not rely on a party's own account or his or her finances, but rather let's just make it up based on certain factors, your education, future employment. But we don't have to take your W 2, we don't have to take your tax return. We can just make it up. In California, they charge about 10% interest on arrears or any money that's owed. And that particular civil code is 685.010. And of course, they charge a fee for that service. That's an additional charge to fathers. So this brings us to my opinion. From reviewing their strategic plan, and just to summarize what we covered, is their goal is to take all of your money however they can get it, which is it to take 80% of your take home pay? It is to sign contracts with the large financial institution, is to increase the number of employers. All of that translate into one main thing. They're going to squeeze your wallet, they're going to search your pockets, and they're going to take every penny that they can from you under this Title 4D program. So this is now part two, where we look at how the program is implemented within the state. So here we have the manual, which is a child support manual, and we've taken certain sections and we're going to highlight what we think are some things you need to know if you're going to challenge them. As we now discovered, it is a program outside within the Attorney General's office, which of course is unconstitutional. So here in item one, which is the regulation code 12102, provide all appropriate services to all cases as needed. That is include welfare and also those with application services, meaning those who apply for services. They're basically provided to everyone. Next, we are the definitions. Here I highlighted section C, which it says the California Central Registry, which is the California Central Registry within the State Department of Justice, which operates a clearinghouse for incoming child support. So take a look at that for a second, right? You are in, all men who signed acknowledgement of paternity, or even the men in the state, they're in the database of the Department of Corrections. You're in the prison database. Well, how did you get there? Did you commit a crime? As far as I know, you have the freedom and liberty to have an offspring as long as the both parties have consented. But how did that turn into a crime that you're already in the database? Well, in our opinion, it, it means that everyone basically within the state of California is in the criminal directory. So why do we say that? We've often said in every one of our videos, 45 CFR 264.30, it says there should be a procedure in which the state agency must refer all appropriate individuals in the family for whom paternity has not been established, for whom support orders have not been established or modified, or anyone. Well, here in California, all of those men that we've been saying that are in the child support program, whether you have an active case or not, you're in the prison database, because that's the only purpose for the Department of Justice database, is to house prisoners, not credit card holders. We have a video called Defending Your Right. This is important now because if you are in that criminal database, well, you need to know how you got in there and how to get yourself out of it. So let's continue on with, again, in the implementation with the child support services. It says here that the local agency, that means a district attorney, until the transition to the local child support agency. Again, here I'm pointing out for the second time, how is a district attorney a person, be the local child support agency, that which is not delegated by the Congress, and then they're the ones who do the transition to the local county. What if the transition never takes place into an agency? Does that mean the district attorney, whoever he or she's delegated, is the Office of Child Support under Family Code 17305? That does not make any sense whatsoever. And here further down in the manual, it says here, they can be measured a performance level up to 75% to 80%. That is, they can implement this program. They don't have to achieve any sort of major goals. They just have to, do it just on par. It's okay. There's no punishment for doing that. So here we now have what is called the quick locator, right? Again, we're talking back to the parent locator database. In this section, it says that California seeks out to add people to the registry. And the form is FSA 200. Again, this database locator and their customers. And inside that database, it's a support order. A support order means judgment or order, including medical support, temporary support, final, termination, remission. And it's regardless of what type it is of support order it is in the database. Again, you are a prisoner. Paternity acknowledgement. We talked early in the beginning. I said focus on that 1.4 million number of acknowledgement paternity. Well, in California, there were 164,088 acknowledgement paternity that were signed. So now we have 164,000 new prisoners in the database. And so now let's look at the program, what it's called, the time standard for establishing support. The time they use is within 90 days, they must establish a support order and, if necessary, paternity. Look at that. The support order and, if necessary, paternity. That means they're not interested in doing paternity. They're mostly interested in the support order. So some people say, well, it is your social security number. That's why you're there. You need to get rid of your social security number. Me, I don't know about that. But one thing I do know for California, paternity is not a factor. They just want you in the database so they can establish a support order. And on item number 13, on the section 12106, if they were unsuccessful for doing that, right, or they attempted service, or they for some reason could not find the father, look further down. The Attorney General is given a certain amount of time in which to seek if a support order is needed in the future. The way I understand that, you only do that to parolees, waiting for them to commit a crime. Well, again, I ask the question, having an offspring, consent, how does that lead to you being a parolee in the criminal database within California? Now, if you disagree with my opinion, please send us an email. We'll be happy to discuss this. But looking at this manual, that's what I interpret this to be. So now look at what is called the enforcement side of it for district attorney. Again, it is being managed by the district attorney. Where is the single and separate agency for this? Right? The absentee parents. It says here further on the page, it says the appropriate enforcement techniques within 30 days of service of process. What they're saying is, Once they've located the father, they're trying to establish an order within 30 days. So if you have paperwork that you're handing in from wherever you get the paperwork from, if you're not recognizing that this process started long before you even submit your first document, then your document needs to address this issue, or else it will be ignored. Let's look at the expedited process. And what's the difference between the standard process and the expedited process? Well, the expedited process just takes fewer days. It takes 60 days as opposed to the 90 days. But if you look at item number 2, which is the expedited process under section 12-109, it says, quote, the time frame for dispositions of action shall apply whether the hearing process is presided over by a judge, a commissioner, or a referee. Well, you know what else they need to probably add? The maintenance crew, a complete stranger. What they're saying is they're going to establish a support order regardless of where you are. They don't tell you whether you're in Article 1 court or Article 2 court. I'm sorry, Article 3 court. It doesn't matter. They are going to establish this by any means necessary, which is unconstitutional. Clearly unconstitutional. And then if they're unable to accomplish that, if they can at least accomplish it within a 6 months time frame, they're considered within compliance. Let's further look at the actions of the district attorney. They also review what is called cases that they fail to enforce. Item number 5. In other words, if the attorney was unsuccessful, that is, they found the father, they tried to establish through by any means necessary to establish the order, but they were failed to do so. The district attorney has now been designated or legislated to what is called initiate future enforcement activities when appropriate. When appropriate means I can continuously go after you until I've established report. Again, that to me is an action of a parolee. That's what you do. You track them to see if they're going to commit a crime. So, again, my opinion on this part 2 is that when you walk into court, quote unquote, child support, you're guilty already. And next, you come out of this a prisoner. And what I mean by guilt is that the process has already started. So if you have paperwork you're putting in, if they look like what is called pre-arguments, you have to recognize that you're in a post-conviction environment. So all of your pre-argument documents are not going to work. You need to write your paperwork to fit as if you're already guilty and that you're already a prisoner and that you're already being tracked by the central database within the Department of Justice under Department of Corrections. So, in my opinion, this is the time that you need to know your rights. And one of them I highlight is Miranda versus Arizona. Why? And I put this here on the screen. You can freeze it, but it starts off with there can be no doubt that the Fifth Amendment privilege is available outside of criminal court proceedings and serve to protect persons in all settings in which their freedom of action is curtailed in a significant way. That is, when you're standing in the middle of the Title 4D process and you see someone with a black robe who could be anyone under the statute, your Fifth Amendment right holds. That means anything you say can and will be used against you. And that's the environment you're in California. So once you step into their forum, court, tribunal, you may want to look to Miranda and start the process as if you are already guilty. Of course, Miranda versus Arner was decided in 1996 by a majority. Chief Justice Warren, Justice Black, Justice Douglas Brenneman all joined in on the decision. We have a video called Know Your Rights. This, if you're in California, you need to know your rights. So this brings us to one of our sections called our call to action, or the third part of this video called your remedies. And we start off with this. We understand that 652, the duties of the secretary shall establish a separate organizational unit. But in California, that unit started in the Office of Attorney General. So that's a challenge on your part. So that secret department that I had at the beginning of the video is actually Office of the Attorney General, not from the Department of Health and Services. So jurisdiction is one of the questions, and your paperwork needs to match that you are challenging your environment. Where are you? Are you a prisoner? Are you guilty? And if that's the case, then I need my Miranda rights. Next, your paperwork should be targeted at the Attorney General's office. Whoever that director takes the marching orders from the Attorney General. Therefore, we recommend the color of law form. We recommend reading the Attorney General's colleague letter. As you know, it was rescinded. But motion to dismiss for failure to join an indispensable party should be one of your access. In other words, how are you guilty when nobody showed up? You just became guilty without a trial, without a representation, without putting in evidence. You're just guilty, in our opinion, under the California Title 4D program. So let's look at one of the remedies you need to focus on if you're going to take on or challenge the Title 4D in California. You want to look to your jurisdictional challenge specifically around the young, what is called the young doctrine. And that is any one of those staffers or people acting against your constitutional authority, they are stripped of their official representative. In other words, they can be sued in federal or state court. And that's Pennhurst State versus Alderman. Yes, you can challenge them, and you challenge them with jurisdiction. You challenge them, and the mother is not a part of this process. This is you believing that you're already guilty, and their goal is to push you through the program. So this is where you start, or one of our suggestions of where you start. Also, you review notice of claim. That is fraud. For example, bringing you into court, family court, for one issue, and then turn around and you're now guilty, and they're going to establish support with or without your permission, or with your consent, with 4 police officers standing around you. Look to this statute. And of course, we have a video called the 5 lawsuits. Here is where the 5 lawsuits comes into play. Look at your environment, the people around you, the magistrate, the quasi judge, the police officer, the sheriff, anyone around you. While you're in the California system, they are subject to your lawsuit. So this brings us to the end of the program, where we said, if you disagree with anything that we talked about within the California process, please feel free to email us. We ask that you like and subscribe to our channel where we can, and please press that notification bell so that we can bring you more research on the various states and the implementation of the child support program. Also, we're humbly asking for a donation of $25, a gift or a donation, just to help us to put together more information and to do more research. And it takes time to do research on the relevancy within the law and your rights within the child support program. And that brings us to our end. We have a few videos here we'd like you to review again or refresh yourself. So in our opinion, we feel that the California Child Support Program, as they implemented it, starts off with you being guilty. And where the guilt starts, one way is at the acknowledgement of paternity form, or the other way is they just created it as long as you have an offspring within the state. However it's done, we feel that the process treats you as if you are already guilty, and they decide to track you, which we call the parole process. Thanks for listening, and have a good day.